Welcome to MSL Presents A Question of Law. Thank you for joining us. This program is brought to you by the Massachusetts School of Law and is shown nationwide. The topic for today's show is at-will employees. According to Fred Golder, suing your employer is a declaration of war. In his new book on civil rights, Fred tells us there's a crisis in the workplace and in the courts. Do you know what your rights are and how to protect those rights? In the half hour that follows, Fred will tell you that, like it or not, an employer can fire you for good reason, for bad reason, or no reason at all. So it's important to know exactly what your rights and options are. Fred Golder has spent a lifetime working for the underdog, practicing employment law in the Boston area, resolving thousands of cases. He has taught at various universities, including the Massachusetts School of Law, Northeastern, Emory, and Harvard. Additionally, he is a writer of numerous publications, including his newest book on civil rights. Welcome, Fred.
Well, thank you very much for inviting me. This is actually the first book that I've written for the general public because I have a passion to make sure that people know what their rights are, know how to protect their rights, and hopefully avoid some of the horror stories that are contained in my book.
Well, I hope our audience will gain a lot of insight from this show, Fred. Fred, before we begin, because we're going to talk about at-will employees, specifically, who is an at-will employee?
Most everybody is an at-will employee unless they're employed under a specific written contract, and there are very few of those. And then there's another segment, which are the people who belong to unions.
Like teachers.
Teachers, firefighters, police, people that belong to unions are protected under collective bargaining agreements, and they have certain rights to civil service protection. But the vast majority of us are unprotected, and we can be terminated for good reason, bad reason, or no reason at all.
Fred, in your book, you discuss a situation where a gentleman had worked 45 years satisfactorily at a company, and then he is terminated 1 year before his scheduled retirement. Did the court uphold that termination, or did they find wrongful termination?
Well, unfortunately, the company was very, very foolish. They simply could have given him a severance package, and he would have been glad to go. Instead, I had to bring a lawsuit. We're very fortunate. We were successful. A substantial verdict against the company after 5 years, and that's what happened to the company because they simply refused to treat him fairly and humanely.
Fred, are there federal laws or state laws that protect workers that are over the age of 40 or 45 or 50?
The Americans with this, there's actually two laws. The Age Discrimination in Employment Act is a federal law that protects all workers age 40 or over. You cannot discriminate against them on the basis of their age. And most states have state laws that prohibit discrimination on the basis of age. Massachusetts has a law against age discrimination, which is pretty similar to the federal law.
Are there any other federal laws or state statutes that protect workers?
Absolutely. In terms of discrimination law, Title VII of the Civil Rights Act of 1964 protects people in certain protected categories like religion, race, color, national origin, and sex. The Americans with Disabilities Act protect workers who have impairments of a major life function. We also have state laws that protect against the same kind of discrimination. And in addition, in Massachusetts, we're one of the very progressive states. We have a law that prohibits discrimination against people on the basis of their sexual orientation. There are also some state laws and federal laws that protect in certain situations, for example, when people are whistleblowing. Whistleblowing is a term that people have heard about, and there are actually state laws and federal laws that protect against certain types of whistleblowing.
Fred, I'm going to quote something from your book. You write, even if you have a clear-cut case of discrimination, and even if you prove that case in court, you can still lose. Fred, how could that be so?
Well, the problem, and it is in my book, we all have very unique filtering systems. Each one of us filter information in a particular way. Consciously, subconsciously, and unconsciously, we perceive things. And sometimes we're not even aware of the fact that we have these unconscious and subconscious biases that impact and affect us. So, for example, If I have a case of race discrimination and I have a racist on the jury, either conscious, subconscious, or unconscious, that racist will have a tendency to find against my client even though the evidence is very clear. If I have a judge who is not competent, if I have a judge who has a bias, the judge may slant the case in a way that will impact and affect the final outcome, because the system is run by people. People, jurors, judges, and if they have biases, it can affect the result and the outcome of the trial. Unfortunately, anytime you go to court and you have to rely on other people, you have those risks.
It's a risk.
Exactly.
Fred, what rights generally do at-will employees have?
Well, they have the right to be free from discrimination based upon the categories that I previously described. And there's also several other common law and statutory rights that have started to be developed by the courts. And the most frequently used to protect workers is what they call a public policy exception to the employment at will doctrine. What does that mean in simple terms? It means that you cannot discriminate against an employee or terminate an employee because the employee has exercised a right that the law allows him. For example, if you apply for workers' compensation and you're terminated because of that, that's a violation of public policy. If your employer tells you to lie about something and you refuse to lie and you're terminated because you refuse to lie, that's a violation of public policy, and you could bring a claim because of that. And the third broad category of public policy is if your employer has done something bad, like, for example, illegally polluted the waters, and you went to the state or federal agents to turn your boss in, to blow the whistle, you have exercised a right, and the law says you cannot terminate someone for having cooperated with state or federal authorities in terms of illegal acts.
Fred, as I understand it after reading your book, in addition to these public policy exceptions, that there are a number of tort claims that are often used by employees to sue their employer successfully. I wonder if you could tell us what an employee needs to prove to be successful under a tort claim.
Okay. Yeah, just like in any other situation, if the employer has made false statements against the employee, against the worker, you may have a claim for defamation. So even though there's an employment relationship, an employer-employee relationship, that doesn't give the employer authority to defame the employee. It doesn't give the employer authority to do many other things, so that if the employer commits a wrong against the employee, such as defamation, or such as interfering with some advantageous contractual relationship, the employee would have a right to bring a claim against the employer. There may be issues involving invasion of privacy where the employee would have a right to bring a claim against the employer. And they're always they're developing new theories all the time. We have aggressive employee advocates out there who are trying constantly to develop avenues of relief for workers. Now remember, the goal always for the worker is to be treated fairly and humanely in the workplace. If the book says one thing, if it teaches people one thing, I'll be a happy person, and that is treat people fairly in the workplace, treat them humanely in the workplace, and it's unlikely that you're going to be faced with a lawsuit. But if you don't treat them fairly and humanely, well, you better watch out, because
you're right around the corner.
I'll be knocking on the door.
Fred, what is this notion, this implied covenant of good faith and fair dealing? What is that all about?
Well, that concept developed from a very interesting case. A gentleman by the name of Orville Fortune. That's one of the earlier cases back around 1977. And Orville Fortune had been working for about 25 years for the National Cash Register Company, and he was paid on a commission basis. And he had finally got the sale of his lifetime, the best sale he ever had in his entire life. So the employer says, wow, we got a great idea. We'll terminate him before the money comes in, and we'll deprive him of this commission. Well, the Supreme Judicial Court in Massachusetts said, you can't do that. If the person has earned the money by virtue of his work, you can't terminate him to deprive him of a commission to which he should otherwise have been entitled to. And they said, we will imply that in every contract there's what they call an implied covenant of good faith and fair dealing, which means that the employer cannot do anything which will deprive Orville of his proceeds of the commission. And they've used that doctrine in very limited situations. We hoped that when they first established that doctrine that we'd be able to use it for everything, and unfortunately the court has been very restrictive.
Fred, a different topic. At-will employees. Sometimes they receive handbooks or personnel policy manuals. Is there an argument that could be made that sometimes these other documents would convert the at-will employee to an employee under contract?
That's an argument that we make constantly. And very oftentimes, what the employer wants is the employer wants to encourage loyal workers. So they have these wonderful policies in place, but the point is, when they want to enforce them, the employer says, oh, they're just policies, they're not part of your employment relationship. Many of the courts have basically started to use that and say you can't do that. You can't tell the employees they're going to get certain rights and then take them away with the other hand. So many of the employee handbooks that you'll see will have disclaimers that this is not to be considered an employment contract. Many of the courts are starting to say, hey, look, you can't have it both ways. If you've got policies, you better enforce them. And some of the courts are treating those as employment contracts, as part of the employment contract, even though they have disclaimers.
Fred, in your book, I read a number of instances in which employees have sued because they received a negligent evaluation. What is that all about?
Well, one of the important things is when you are an employee and they have evaluation processes, if they have a process that works well, then you know what your problems are and you can correct them. If you don't know what your problems are and you don't correct them, it's kind of nasty for the employer to say, well, you didn't correct the problem that we saw, but how could I correct the problem? I didn't know there was a problem.
But if you're at will, you can be terminated, right?
That's right. But let me tell you one really interesting case. It had to do with a person of color who, according to the supervisor, wasn't doing her job. So instead of evaluating her properly, he said, well, I'm not going to evaluate her truthfully because I'm afraid if I do that, she's going to accuse me of race discrimination. So he did not give her a true and proper evaluation, and as a result, 2 years later, they terminated her for poor performance. And she said, well, wait a second. You never gave me the same opportunity that you gave to white people, because white people who had problems, they would have been notified, and the court upheld her claim.
Wonderful. Fred, we need to take a break here for just a moment, and we will come back and talk some more with you about your new book on civil rights. Stay tuned.
Hey, this phone's taken.
Son, will this help you?
Maybe the last thing you would do for somebody should be the first.
Thanks. Hey, I appreciate it.
A message from the Credit Union Foundation and your hometown credit union.
A baby changes everything. It turns a couple into parents. Your parents into grandparents. Your brothers and sisters into aunts and uncles. A baby changes how you invest and do your taxes. A baby changes what you buy, the way you drive your car. Everything. And while change is good, usually, you can always use a little help. That's why the free consumer information catalog from Pueblo, Colorado offers you more than 200 free and low-cost federal publications. Just call toll-free 1-888-8-PUEBLO and help is on the way, even if you don't have a baby.
Welcome back to MSL Presents A Question of Law. We're here talking with Fred Golder about his new and latest book on civil rights. Fred, different question for you. Are there special laws or protections for public sector employees?
There's civil service that protects public sector workers, the Merit Systems Protection Board in the federal sector. There's a Federal Labor Relations Authority in terms of collective bargaining issues. More than half of the public sector people are represented by labor unions, and so they have rights under collective bargaining agreements. So it's interesting that there is actually much more protection from arbitrary actions in the public sector. You cannot terminate someone in the public sector unless you have a good cause, unlike the private sector.
Fred, what should an employee do when they first sense trouble on the job?
Well, I am very firmly convinced that the way to avoid problems is to be very proactive, to always be there, to be the kind of person that the employer, the supervisor is going to say, well, this is the person I want to work because they're always on the ball. However, if you start to sense that something is going sour, what you want to do is you want to have an exchange with your supervisor. You want to try to find out what the problem is, and you want to try to correct it. At the same time, you want to document things, you want to keep very copious notes, you want to keep a diary, so that in the event that the problem escalates later on, you'll have been keeping a diary. Usually, employees know when things aren't going right, and it's very important for them to keep really good notes to use if they need them later on.
Should you consult an attorney before you do anything?
I would suggest that if you have the opportunity, definitely consult a lawyer. Now, you want to go back to a really interesting case with Clarence Thomas and Anita Hill. You may have recalled that case. And if Anita Hill had come to me and said, Clarence Thomas is creating all these problems for me in the workplace, what do you think I should do, Fred? I would have suggested to her, which is exactly what she did, get your resume together, get as many people as you can to help you find your next job, and use Clarence Thomas to get your next position, which is what she did. She became a law professor at a university, and that was a good result for her because she got away from that environment. And that's some of the things that employees should be doing and can be doing.
Would you have advised her to proceed for sexual harassment?
No, I probably would have told her, get on with your life. In other words, the last place you want to be if you have a real problem is in court. You want to try to avoid that. The best thing to do is, what about your life now? Think about what you want to do with the rest of your life.
But what about all those other women that might get sexually harassed? Don't you have an obligation to do something to prevent that, to report it?
Well, you know, you raise a wonderful point. It's interesting that very few people ever have the courage, and it takes a tremendous amount of courage to sue your employer. But if you do that, you impact in incredible ways. Look at the recent case that came down from the Supreme Court, the two cases involving, there was the Ellerth case and Farragut, two cases involving sexual harassment. Now, there are only a couple of people involved in that, but those two people changed completely the way employers now have to deal with sexual harassment issues. But what do you say? Personally, it's better if you move on and get yourself a better position, but from the standpoint of how you impact on the rest of the world, you do want people to come forward, and you want them to be courageous, because that's the only way things change.
That's right, Fred. Fred, what is the best way to solve workplace disputes?
Well, I think the best way, and if the employers are very smart, it's incredible. I've done some research, and it turns out that it costs employers about $50 billion a year. I know that sounds staggering. In terms of what they pay out, in terms of what it costs for legal fees, a fraction of that a fraction of that, they could develop what I'd like to call dispute resolution systems. They could build them into their organizations so that when people are having problems, they actually have a mechanism for resolving those disputes in a peaceful way.
Well, if the company has a formal procedure for resolving disputes, like sexual harassment claims, do you recommend the employee go through that procedure?
If the employer takes the process seriously, and you really are talking about people at the top, if the people at the top buy into a resolution system, then it's generally the best way of approaching it, because the employee will be able to spot the problem supervisor. The company will then be able to take action, and that way the people that come after them will benefit from his or her action.
How does an employee find the right lawyer? Not all lawyers have a specialty in employment law.
That's right. In fact, there is a number of groups that absolutely concentrate in this field. The National, not that I want to make a pitch, but the National Employment Lawyers Association is a group, a national group of lawyers who advocate for workers' rights. These are people who are dedicated and passionate about protecting workers' rights. And if you find an employee's lawyer that's associated or affiliated with the National Employment Lawyers Association, you're likely to get someone who is knowledgeable and someone who will be a very strong advocate. The bar associations have labor law sections. You can call any of the state bar associations and ask for them the chair of the labor law section. You can get lawyers from that source. The American Trial Lawyers Association, there are groups, and what you really want to do as an employee, as a worker, is to make sure that you are getting referred to someone who concentrates in the field of labor and employment law.
Fred, will most of these attorneys take the case on a contingency basis?
It depends. Some lawyers will take it on a strict contingent basis and some will not. I sometimes will do that, but let me tell you what turns me on and what turns most of us on that advocate for workers' rights. If we believe in the cause that this particular worker has, and if we like the person, genuinely like the person, very oftentimes we will take the case on a contingent basis, particularly if it's an egregious case and it's likely to result, even though it's going to take 3 to 5 years to litigate, if it's going to result in a good end, then we're likely to take it. And I don't want you to think that all cases litigate for 3 to 5 years, although you've got to expect it. At least 75% of these cases are resolved and settled without going through a full-blown trial.
Assuming that the employee has to go to trial, what can the employee expect to face in court? What's it going to be like?
Well, that's the problem. You never know. You may get an incredibly competent judge who gives you a fair, impartial trial, and you may get fair and impartial jurors. On the other hand, you may get judges who are bigots, sexists, racists, and incompetent. See, the thing is, how do you get to be a judge? Well, you get to be a judge because you're a political animal, you know the right people, and that's how you get to be a judge. And if you happen to be incompetent as a lawyer, you don't become competent as a judge when you become a judge. So, and that's the luck of the draw. There are some really excellent judges, but then on the other hand, there are some judges that are not so excellent. And you have jurors, and the jurors are not likely to be sympathetic, even though you'd say, well, wait a second. Most jurors are workers. Why wouldn't they be sympathetic? Well, they're not sympathetic for a number of reasons. They don't like plaintiffs. They don't like plaintiffs' lawyers. And they say, why is he or she whining or complaining? Why doesn't she or he just suck it up and take it? Because I have a worse situation, so why should I give this person any money? It is difficult.
You say in your book, Fred, that law and justice are distant cousins. What do you mean by that?
Well, exactly what I mean by that. In other words, you don't necessarily get justice in the court because the employer, the lawyer representing the employer, is not there to do justice. The lawyer there is to do whatever he or she has to do to win the lawsuit. And if it means confusing the jury, if it means taking evidence, reducing evidence. Remember now, the employer controls all this information. The employer knows what it did, why it did it. In fact, most of the time, if the employer wants to get rid of an older employee, before they do that, they consult with their lawyer and they say, how do we do it without violating the law? So it's those kinds of things that create such problems for workers.
Do wrongfully discharged employees usually find some type of justice?
Well, if 75% of the cases get settled, I suppose a little justice is better than none at all. So every time a case is resolved in a way that satisfies the needs of the client, then I would say it works. But for those 25% that are forced to go to trial, if they get an incredibly competent judge with an it's the best. There's nothing better than having a competent judge and an impartial jury, well-informed, understanding jury. That's a great high. But unfortunately, the opposite of that is when your judge is not competent and your jurors are not paying attention, they're not impartial. And there have been cases where I have found out after the fact that I had biased jurors. Forget about biased judges. I sort of know about that. But people who have agendas, and jurors sometimes have their own hidden agendas that you may never know about.
Fred, we're just about out of time, but in the last few seconds, how does an employee, if they're fired, know if they have a valid cause of action, one they'll be successful on?
Well, if they read my book, and that's one of the reasons I actually wrote the book, I want it to be a guide so that a worker says, look, this is what happened to me. Do I have a claim? Well, if they read the book, there are parts of it will tell you in very simple terms, if these are the facts that happened, then you do have a cause of action.
And we're out of time, Fred, so they'll have to read your book. Thanks for joining us. Stay tuned until next time. Bye-bye now.